Hello, everyone. We're waiting for 1 or 2 more minutes for everyone to come in, and then we'll start the webinar. So yeah, let's wait for another minute or so. Yes, let's start. Hello, everyone. Welcome to the webinar. This is the 7th webinar in our CSRD series. In this webinar, we will focus on legal compliance of CSRD. I'm Lawrence, Sustainability Solutions Manager at Coolset. Next to me is my colleague, Jasper, and our co-host, Theo Verhoeven. Would you like to introduce yourself, Theo?
Yes, thank you very much, Lawrence. My name is Theo Verhoeven, as you already know. I'm a lawyer specialized in sustainability. I'm also completing my master next year in environmental sciences. And well, I'd like to specialize in the CSRD and try to tell you something interesting today about liability and opportunities.
Thank you, Theo. Jasper?
Good morning, everyone. I'm Jasper, Sustainability Researcher at Coolset, and for the past year I've been working on CSRD, trying to understand it, trying to communicate it with our customers, and trying to turn it into a solution for our software. So today I'll bring some of that expertise to the webinar, and of course support Laurens and Theo in the things we'll be sharing with you today.
Thank you, Jasper. Before we kick things off with all of you, let's go to the agenda for the day. What are we going to talk about? So the plan for the day, Jasper is going to tell you a bit more about CSRD and ESRS. Theo will take over and talk about fines and penalties, the legal risks, liabilities. He will explain some example cases, and I will tell you a bit more about solutions. At the end of the webinar, we have room for questions. We will try to answer them at the end of the webinar. Otherwise, we will answer them by email. On the right side, bottom right, you have the questions and the chat. Please ask your questions in the chat. On to you, Jasper.
Thanks, Laurens. So we have a poll to get us started today. I'm just wondering where the understanding is of CSRD. Let me just launch the poll. So what is your understanding of the CSRD? Just getting started, I'm getting the hang of it, or I have a deep understanding. What I often see is that in these webinars, there's a bit of everyone. So I think that's a great combination, because it kind of shows that while we also are able to share the knowledge with people that are getting started, there's also enough for everyone to learn that's already further in the process. So let's see what the results are. Most of you are getting the hang of it. So we're seeing that now as well in the landscape of CSRD. It's been around for a year now, more or less. And in that past year, people have really started to kind of dive into it deeper, started sharing more, having more sessions with each other, trying to understand it. And of course, the webinar landscape has also developed. As Laurens mentioned, this is our 7th webinar. And we're seeing that as we do those more often, that the knowledge level is also increasing. So interesting to see that, a lot of you are getting the hang of it. Before we get to the technical part where Theo will talk about the legal requirements, just to give everyone a quick rundown again of what we're going to be talking about today, which is the CSRD, or Corporate Sustainability Reporting Directive. It's a new EU directive which requires companies to provide detailed information on sustainability and social impact, and focuses on the famous environmental, social, and governance criteria, which are also often called the ESG criteria. The overarching goal of all of this is to increase transparency and comparability of sustainability performance of EU companies. And that's also the reason why we're focusing today on the legal requirements, because in order to make it comparable, you need to be accountable for the actions that you, or at least the reports that you write. So that's why we're sitting here today. It's also interesting to note that there's a big difference between CSRD and ESRS. CSRD only dictates who has to report and when it has to be reported, whereas the ESRS dictates what must be reported. That means that the ESRS has some 1,100 data points on which companies must report depending on their double materiality assessment. And these data points are broken down into the ESG pillars. So the environmental, social, and governance pillars. I'll share that in a slide in a second. And the first step of the ESRS is the double materiality assessment. So I think most of us attending today have heard of it before, but it's basically a step wherein companies decide, okay, of these 1,100 data points, which ones are material to my company, or in different words, which ones are relevant to my company. On the right here, I have an example of one of those reports from the environmental topic. It's from the EFRAG. The EFRAG is the organization behind all of these sustainability regulation revolving around the CSRD and the ESRS. We'll be referring to them in this webinar once or twice because they are the organization behind all of the policies. So moving on to the ESRS topics. So we have the sustainability matters, which are these 10 topics that fall under the pillars of ESG. Within those topics, there are also subtopics. And in total, there are 37 subtopics and 72 subtopics. So we won't be getting into those today. If you want to know more about that, let us know via email. We'll be happy to share previous webinars with you. But it's good to understand the background so that when Theo talks about the intricacies of the ESRS, you have an understanding of where we stand. It's also good to note, as I talked about just now, that the double materiality assessment determines which of these 10 topics you ultimately end up reporting on. And the decisions that you make in order to get to that materiality conclusion, that's really important. So when you make statements, when you make conclusions, that's going to be brought by the auditor, and the auditor needs to either agree or disagree with your conclusions. And what Theo will also be talking about is why those conclusions are important and why it's important to stay within the limits of the legal requirements. Also good to note is that ESRS E1 climate change is almost always material, as it's one of the requirements within the EFRAG documentations that E1 is always a very important topic for companies because either they're emitting a lot of CO2 or they have they're directly impacted by the consequences of climate change. So to kind of sum it up on a high level, once you've done everything, you've done your DMA, you need to start reporting. And this reporting is where it gets tricky because on the one hand, you have the requirements from the EFRAG. On the other hand, you have also the requirements from the European Union on what has to be reported and how it has to be disclosed. So two things need to be clear in this process. On the one hand, you have the process where you need to decide what stakeholders were considered, what thresholds were chosen, for example, and why that has been done. And then you have the outcome. So here you talk about what sustainability matters are ultimately material. And within this process, the auditor will look more at the process because the process leads to the outcome, and you as a company have a lot more expertise on the outcome than the auditor does. So it's good to keep that in mind. But I think the focus of today is also really on the process. So how you make sure that the process is aligned with the official requirements, and what are the consequences if that process is not done in line with the ESRS requirements. Here a quote from the EFRAG that I quickly like to share because I think it shows some of the reasoning and the thinking of the EFRAG. The ESRS do not prescribe specific documentation, but it is reasonable to expect a certain level of documentation to be needed for internal purposes and help assurance providers to perform their work. So what we see here is that they do not prescribe specific documentation, so it's up to the reporting company to what extent they disclose certain information, but also how they interpret EFRAG guidelines in certain ways. And it's a very fine line as to what is up to your interpretation and what stays with the official requirements. And I think that's also why many of you are attending today, is to learn more about, okay, well, if you look at the fine line and where you cross it, what are the consequences of crossing it, and what does it mean to actually cross that line? So I'm handing it over to Theo, and before I do, I'm just really curious as well about the legal understanding of the attendees today. So let me just launch this poll here. So what is your understanding of the legal requirements regarding CSRD? I fully understand the legal context. I have a basic understanding. I don't know much about it yet. So we're seeing that most of you have a basic understanding. I would say that that's also where I was finding myself for the longest time. So really trying to understand the legal requirements of CSRD. Now also having talked with Theo for a while, I understand it better. But we also hope that the webinar today will move some of you from the I have a basic understanding to I fully understand the legal context group. But of course, if you do have questions, feel free to ask them in the chat, and then we'll answer them after during the Q&A. So over to you, Theo.
Yes, thank you very much, Jasper. Good morning, everybody. Since you just mentioned, Jasper, that the most people seem to have a basic understanding of the CSRD, perhaps I add a few lines to what the CSRD is from a legal point of view. As many of you might know, the CSRD is a directive, Corporate Sustainability Reporting Directive, which means that this directive has to be implemented in national law. The ESRS is not a directive. That's a directive that doesn't have to be implemented. So it's this is a directive that has to be implemented in Dutch law. The Netherlands lacks massively. There is an implementation law not even implemented, but that won't be addressed today. As you might know, the CSRD, as shown in this slide, is a new directive. It amends the original non-financial reporting directive and obliges companies to report about their sustainability topics. When we go further one slide, then you can see, thank you, that there are several risks. I'll go into that deeper in just a while. If you do not comply in time, there are risks of fines and penalties, which we will explore some more in the next. When we look at the fines and penalties, that can be because of the failure to meet deadlines or inaccurate reporting. Jasper mentioned it already. And there might be legal actions and financial penalties through national regulations. I will address those in a minute. If we look at the risks of litigation, that's sheet 11, Jasper, then there might be litigation because perhaps stakeholders are dissatisfied, or investors or non-governmental organizations, for instance, think about Milieudefensie or other organizations like that. They want to have the companies to comply with the CSRD. Stock companies might have problems. I'll go into that in a few moments also. Suppose that a stock company has a problem with their reporting, and the reporting deems to be false. That will do something with the shareholder value, not the stakeholder, but the shareholder value. The worth of the shares might plummet. There are also risks of reputational damage. If a company is exposed to, for instance, slave labor, and this comes out, then there's a loss of business opportunities because they have to report it, and that will lead to financial losses, legal challenges. They might be held liable for the loss of the shareholders. So there is some risk in this area. There are also risks regarding to operational disruption. If you're not complying with the regulations, there might be risks involved also, and this might lead to liability for directors and officers, which will be talked about just now. There might also be some data privacy and security risks. If all companies have to report about their sustainability topics, there is a risk that they might disclose confidential information. You don't want to do that as a company. There might be data leaks about confidential information, so that's also something to take into consideration. Before we'll go to the real topics, there might also be some multi-jurisdictional compliance. I mean, with this, I mean, for instance, take a company that has businesses all over the world, such as, for instance, Coca-Cola. In America, they will have some sustainability rules, reporting standards. For instance, the IFRS is working on it. In Europe, they have other regulations such as the CSRD. So that's a big problem for multi-jurisdictional compliance for these large companies, because in Europe they have to comply with the CSRD, later with the CSRD, and in America and China and India there might be other regulations. Now we come to the good part, well, at least the part that's more in my daily life, the risks regarding the CSRD. Of course, when there's a directive, it has to be implemented, and if you don't implement the directive in your company, you do not comply, there's always the risk of fines. Of course, there's also the risk of criminal law and enforcement, because not complying with the CSRD is punishable under criminal law, and that might be enforced by the AFM, that's the Autoriteit Financiële Markten. In Dutch, they will enforce it in a civil way, like civil liability. There might be liability for directors, CEOs, CFOs, also liability for commissioners if they do not look after the company in a sufficient. Liability for accountants, also supplier liability, because in the whole chain of the company there might be risks, and if the company is large and the shareholder has damages because it comes out that the company doesn't comply fully, for instance, due to slave labor or environmental pollution, and then there will be probably proceedings before the Dutch courts. I will not be addressing liability M&A practice. There will be some difficulties with that, but I will not address them today. Insurances, I don't talk about this because the liabilities that arise, they are new under the CSRD. Insurance companies are at this moment looking into it, how to amend their insurances, but we will not be discussing that at this moment. If we look further into the liabilities for companies, if they do not comply with the CSRD in full, there are fines, criminal prosecutions, and enforcements by the AFM. Of course, you have the CSRD has to be enforced, implemented, and the accountant has to audit. At this moment, the accountant has only to control whether the account can give limited assurance, which is not very heavy, and this will change in the future, but limited assurance in the audit is sufficient. If we look at the ways the CSRD can be enforced, then we have the CSRD, then we have, that's the next slide, Jasper. We have assurance audit, that's done by the accountant. That's also a form of enforcement. Also, it can be enforced by Article 2394 Civil Code, and the company can be brought before the court to comply. There's also the possibility of the enterprise chamber. This is the ondernemingskamer in Dutch. Stakeholders such as Milieudefensie or other organizations, shareholders, we can try to have this company before the enterprise chamber. The AFM, Dutch Authority for the Financial Markets, will have to enforce the CSRD, and there is also the criminal liability under the Economic Offences Act of the Wet Economische Delicten in Dutch. Those are the possibilities for enforcement, and those will be also risks for companies. Then we go to liabilities for directors, CEOs, CFOs, members of the board. Of course, there are possibilities to hold directors and CEOs, and so liability under Dutch law. There are 3 articles you can see here that are the basis of this. I will not dive into it very deep because that's a bit too much for today. But please know in the next slide that not every little or slight problem with the CSRD will lead to liability. In order to be liable as a CEO, this is here you see the Dutch text. In English, remember that a director or CEO is only liable if he or she can be blamed seriously. This is the main phrase, blamed seriously. Not every little fault or little misunderstanding leads to liability. You have to think about, for instance, if a company is explicitly not applying the CSRD or reporting explicit faults. So not every little fault leads to liability. One of the articles under Dutch law for liability for directors can be found in Article 249, Book 2 of the Civil Code. If you do not show a good report, then you might be liable if it is misleading. In the Invoeringswet, in the law implementing the CSRD, there's made no remark to this article, but I suppose that this article will also be applicable if your report is not correct under the CSRD. We will have to see that in the future. There is also the possibility liability of directors shown in the various proceedings. This is a QR code. You can find a verdict from a court in the Netherlands regarding the liability of one of the CEOs. Same is with liability for commissioners. If commissioners do not supervise sufficiently, they might, I say might, is of course all in the future, might be held liable. There's one verdict you can read, this, you can find it here, the ECLE number is in the slide. We might also look at liability. This is liability for accountants. They can be held liable. For instance, I am looking, yeah, that's the next slide. I'll get to that. There might be civil liability for accountants, disciplinary liability for accountants, and also criminal liability. That might be rare, but possible. And one of the cases in which the accountant and also the commissioners were held liable was the Vidor case. Commissioners didn't supervise enough, accountant didn't control enough, so both CEOs, commissioners, and accountants were held liable because the annual report was faulty. This might be the case with the CSRD also. I'm quite sure it may take a few years, but once shareholders lose their worth in shares, they will go looking for the persons that can be held liable for it. Okay, well, we'll now discuss quickly 3 cases. We might discuss this later in the questions at the end of this webinar. When you look at it and you look at, for instance, case 1, where a company deliberately fails to comply with the CSRD obligations, then in the examples I've been giving to you, and we look at, for instance, faulty report about pollution, ESRS E2, or ESRS S2 and S3. Think about, for instance, people working in China, which is sometimes slave labor, and this is not reported correctly. Then you can see that under the CSRD, it is possible that fines will be handed out, but also criminal law enforcement might be the case. Directors, commissioners, accountants may be held liable if a director willingly and knowingly reports not correct under the CSRD. Then he or she might be held liable. Same as if the commissioners do not supervise enough, and possibly also an accountant may be liable. But that should be only the case if he or she makes a real big mistake. The next example is a bit more evident. There is the case that the company does not intentionally not comply with the CSRD. In that case, there's also the possibility of fines, possibly criminal law enforcement, but in that case, probably no liability for other parties. Perhaps in the supplier liability, I'll address that later. Last case is there is the case of non-compliance with the CSRD, but it's not intentionally, and this could happen if, for instance, not the correct information is handed to the company by suppliers. In that case, the company doesn't comply with the CSRD, but it's not the intention. In that case, also fines can be applied. This is not dependent on the fact that the company itself didn't know it. Criminal law enforcement might be difficult, and the other liabilities are not in order in that case, I suppose. Perhaps the supplier liability, which is, for instance, the last case, there is insufficient or false information brought to the company by a supplier. In that case, the fault lies with the supplier. Think about, for instance, the case where a company in the Netherlands, shall we say Ahold, take for instance bol.com. Everybody knows bol.com. That's a company from Ahold. They sell goods from a Dutch company. The Dutch company buys these things somewhere in Asia. Somewhere in Asia, the goods are made in China, and in this whole chain, it's reported that it's all with respect for human rights, and at a certain moment it becomes clear that that was not the case. Imagine what happens when you read the paper or you see it in the FD or NRC or whatever newspaper, what it does with the shareholders' value. The shares plummet at the market. The company doesn't know it, but it's still a problem. So in the chain of information, it's really important to look for the right information, because if it isn't the right information, there might arise liability for the fines, criminal law enforcement. And in the case that it's deliberate, well, then you look at the liabilities under C, D, E, and F. That's in short the liabilities that are possible. Of course, it's looking into the future, because the CSRD is not yet fully in force. But in a few years, let's say 2, 3, or 4 years, I think that these cases will be brought to court, and we will learn more about the exact liabilities of the CEOs, the accountants, commissioners, and what more. Perhaps 2 questions we can discuss about it if we have time later on. Does it make a difference when a company assumes a standard is not material, but it is material, or what if a standard, ESRS standard, is deemed material, but it evidently is not, and the report is false? What kind of liabilities arise in that case? Well, if we have time later on, we can look at it. So I think you understand that it's really important to have your reporting in order. That's my contribution for now, Laurens and Jasper.
Thank you, Theo. I hope everyone gets a clear, better vision of the legal compliance with CSRD. Thank you very much. Yeah, let's talk about solutions. How to avoid all these, how avoid legal compliance and fines, of course. So yeah, at Coolset, we have one place to measure, manage, and improve on your sustainability. This is what we call the sustainability management platform. As you can see, it's consisting of two products. So one, carbon management software to measure and analyze and report on your scope 1 to 3 emissions. And on the other hand, we have our compliance management software, our end-to-end CSRD compliance software. Let's dive into the compliance management software. With the Coolset's compliance management software, we provide compliant CSRD software that will guide you through the whole CSRD reporting process. So as Jasper already told you, the first step of CSRD is conducting a double materiality assessment, consisting of stakeholder engagement, media analysis, and of course, assessing your impact, risks, and opportunities. On our platform, you will be able to streamline all your data and conduct this double materiality assessment and eventually identify your material topics. As you can see on the slide, you can identify your material topics in the platform. The example on your screen is pollution. So every topic, you can scale the impact on this particular topic. And on the right side, we will always show you a guide to help you with the process. We will always give you more information on where it is in the regulation. We always give you suggested answers to help you answer this particular data point. Yeah, how to report on ESRS within a platform. After the double materiality assessment, you've decided what your material topics are and on what topics you will need to report. In the Coolset platform, we will only show you the material topics. These topics will only be visible to you, and you will only be able to report on the topics that are material to your organization. So what have we done? Yeah. So what we've done, our sustainability researchers have read the CSRD regulation and distilled it to all the data points available in our platform. In the platform, you can report on all the ESRS that are material to your organization and track progression, as you can see on the bar on top of your screen. The platform also provides task assignment. So you can assign data points to different colleagues. You can ask colleagues to review certain data points if you answered it. And you can also assign different ESRS to different colleagues. So you can divide the workload of the whole CSRD report within your colleagues, within your ESG team or work group. Next to that, our platform offers the feature to collaborate with your auditor. This way you can easily work together with your auditor and give or ask feedback along the way to speed up the process of compliant CSRD reporting. It also gives you a clear view on what to do next and what you can leave behind. If you tag a colleague for either answer a data point or reviewing a data point, they will receive a notification that they have been tagged or assigned to a certain data point. A compliant CSRD report also needs audit trails. Our platform generates audit trails, as you can see on the right side. An audit trail, it means that you can see who changes what. For example, if you're adding a document, updating a status, or answering a data point, or changing an answer to a data point, our platform will show you that audit trail, who did what. Lastly, you can attach supporting documentation. This is important to substantiate an answer to a data point. Many auditors want to see supporting documentation. For example, the pay gap between different colleagues, you have to back that up with supporting documentation from your HR system, for example. Yeah, so that's about it for the Coolset platform. If you want to take a closer look at the platform for other features, you can reach out to me or to Jasper. Our email addresses. If you have more questions about legal perspective, our emails is also in the slides. So I think we can go to the questions. Thank you.
Microfoon, Jasper.
I was muted. I hope everyone hears me.
Yeah.
Yes, thanks, Laurens, for that. For now, let's answer some questions that are in the chat. I think most of them are directed at Theo, so I'll just read some of them out, and then Theo, you can have a look at answering them. We have a question from Valeria. How do you prove if something was deliberate or not?
That depends. It's typical lawyer answer. It depends what kind of case it is. If it's a criminal case, het Openbaar Ministerie has to prove if it was deliberate or not. It will have to work out in the verdicts of the courts in the future. But in a criminal case, the government, so to say, has to prove whether it was deliberate. One could say that it's so very, very, very obvious that everybody would suppose that's deliberate, then it can be deemed deliberate. But in a criminal case, that's the government, Openbaar Ministerie, so to say. But if we're talking about the civil case, the plaintiff has to prove that it was deliberate. And that's a matter of the law regarding proceedings.
Thanks, Theo. Another question from Joop. I can imagine that large listed companies will seriously take into account the liability standards following from the CSRD. What is your opinion on the applicability to smaller listed companies? Do you see liability playing a serious role there? In other words, is there a serious risk for these companies?
Most definitely. Good question. Of course, the large listed companies will have to take into account the CSRD, but also the smaller listed companies. In the following years, I think it's 2026, that the smaller listed companies will have to comply with the CSRD. But still then, liability will play a role, because one of the examples I gave early on, if you have, for instance, a pension fund that's investing in a company, also possibly with a smaller listed company, and the board of directors have made serious faults with the reporting, and it comes out that a certain company, for instance, has polluted massively in the production process, then this will do something with the shareholders' value. And mark my words, there's a large risk that the CEOs and the directors will be held liable for this. And this is the same with the directors and even possibly the accountant. So the risk is serious for these companies also, yes.
Thanks. Question from Jan. For the companies which have to report over financial year 2025, but not seriously started, what do they have to prepare before the 31st of December 2024?
It looks a little bit late, if you ask me. The first thing what I will do, I will assemble a team, sit together, and hurry to comply. But you have to remember that if this company has to report over 2025, the report regarding the CSRD has to be ready ultimately November 2026. That's the final date for reporting. So you have some time, but I would hurry if I were you.
I think the message is clear there. Question from Nicole. Do you provide assistance in determining whether a company falls within the scope of CSRD reporting requirements. Maybe I can also jump on this one. So there are some very clear requirements for who falls under the scope of the CSRD. For next year, that's companies that have 2 out of the 3 criteria for what determines a big company. So that's either 250 plus employees, 50 million in turnover. Is it? Yeah. And then 25 million in assets. So if you have 2 out of those 3 criteria, then you have to report on CSRD for next year. And then for the year after, it's going to be the same 3 requirements, but then with lower barriers to entry, basically. So what I can do is I can share with you our resource on that, and I'll just send you an email after this webinar with the exact guidelines. If anyone else wants those resources, let me know in the chat and I'll share that with you as well. Question from George. Which body or entity is going to be reviewing and assessing these submitted reports? How will that body decide whether a report is adequate or not?
Shall I answer this one, Jasper? Yeah.
Yeah, I think that's a question for you.
Under the CSRD, there are 2 possibilities which body is going to control the reports. The Netherlands has chosen for the accountants to audit the reports. So the accountants have to control whether the reports are correct. But as I said earlier on, that's only a limited assurance. And the Autoriteit Financiële Markten, the AFM, is controlling the accountants. So there's no body directly controlling. Perhaps the AFM will try to do this, but there's a real gap regarding knowledge on this topic. So remember, the AFM is ultimately responsible for the enforcement. This is done by the accountants who have to give an audit report regarding the CSRD. That's
thanks, Theo. Okay, then a question here. So we have 3 more minutes. So I'll just select a question that I think for now is relevant for the group, and then we'll get back to those that we haven't answered over email. Question from Claire. In case you voluntarily report under CSRD, for example, Coop, which is a Dutch supermarket chain, what does that mean for liability?
That's an interesting question. My first reaction would be no liability, because it's stated simply that certain companies have to report. If you're not such a company, well, then you don't have to report. But being said that, if you report about information and you do this, for instance, for shareholders, although you're not obliged to report, I think it's possible that you can be held liable if the information you gave is deemed not to be correct afterwards. So if I'm an investor and I want to invest in Coop, small company, and for me it's important that this company is green, so to say, complies with the CSRD, and afterwards it becomes clear that that's not the case, well, then I might be quite angry. And in that case, if that information given voluntarily is not correct, that might lead to liability, but not from the government, not from a criminal point of view.
Yeah, I think that's very clear. Okay, one last question from Putri, and then once again, if you have further questions, maybe they also come up after the webinar, when you're having lunch, discussing with your colleagues. Feel free to send an email to either of us. Our email addresses are in the slide. And of course, the webinar recording will be shared with you after this session automatically, so you can review all the slides again. So last question from Putri. For companies who have to report 2026 for financial year 2025, the report needs to be ready in November 2026, and then a question mark. So I think the question here is that can you confirm that that's true?
I'm in doubt now. because I think that for listed companies, they have to deposit their report earlier. I will look that up. I will separately reply to Putri on this subject.
Perfect. Thanks, Theo. And thanks, Theo, as well for everything and you've explained to us in the slides today. I think it's really useful to kind of have the combination of the CSRD background that we've provided, and then also to have the deep dive from a seasoned lawyer. So thanks for that, Theo. And for now, thanks everyone for attending today. Thanks also for your great questions. We'll share with you the webinar slides after this recording, and we'll let you know about the next webinar, which we'll be hosting in the beginning of January. And for now, thanks everyone for attending, and have a very lovely Wednesday.
Bye.
Thank you, Jasper. Thank you for your cooperation. It was nice to do.
Good to hear. On to the next one, I'd say.
Yep.
Bye.
You also, Laurens, of course. Bye.
Bye.